Over the weekend, I had a series of kind of conversations on X with posts about what I consider to be the bottlenecks or the choke points standing between American citizens in the anti-gun blue states and their ability to conceal carry handguns consistent with the Supreme Court's decision in Bruin. And I just want to go through what I think are the main choke points or bottlenecks that the anti-gunners have really contrived or made up to try to make it hard for Americans to be able to conceal carry in their specific states. And I just want to run through them with you to see if you agree with what I'm saying and if there's anything I'm missing or getting wrong. I'm looking forward to your comments at the end of this video, but let's get right down to it now. Hey folks, I'm Mark Smith, host of the 4 Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so you may remember Operation Choke Point. Operation Choke Point was designed by Barack Obama and his administration to basically make it difficult to engage in certain businesses, including, for example, payday lending and, of course, the buying and selling of firearms. And they came with all sorts of ways to engage in essentially an effort to debank people, make it harder to engage in the financial business of those industries. Now, I want to use that metaphor here because it seems to me from a review of what I've been seeing on X and on other research I've been doing, that there are specific bottlenecks or choke points that have been developed by certain anti-gun states, the usual suspects, in the typical blue states that don't want you to be able to exercise your right to keep and bear arms. And I just want to run through these with you and to see if you agree that I've identified the main ways that the anti-gunners prevent you from getting your concealed carry permit, or if there's anything I'm missing, or maybe you just disagree with my entire thesis altogether. Well, as we know, when the Founding Fathers created the United States, they engaged or they tried to create something known as federalism. And what federalism is, it's really lauded as like the laboratory of democracy, where every state can engage in inventions or experimentation with public policy innovations. But what's going on here, as I see it, is the anti-gun states of places like Massachusetts, New York, New Jersey, California, Hawaii, and the like are all looking to one another to try to make it as difficult as possible for people to be able to conceal carry their guns and get a license, which should be a shall issue permitting regimes at a minimum in light of the 2022 Supreme Court decision in NYSERPA versus Bruin. Indeed, in the wake of Bruin, these anti-gun states, while claiming to be shall issue permitting regimes, to some degree they are, but they have come up with strategies for regulatory resistance, and they're sharing their innovations not for good public policy purposes, but to make it harder and harder for people to exercise their fundamental right to keep and bear arms under the Second Amendment. And they've done this in ways that make it harder for people to get these licenses, either through undue delay or undue costs, including money fees, as well as time and other resources that have to be devoted to exercise this fundamental right. And I just want to run through kind of where I'm seeing the games being played if you look at these different states. And it seems to me these are the various obstructions that are popping up and starting to be shared and replicated in the usual suspect anti-gun blue states. The first thing is, it seems to me there's an attempt to engage in staffing bottlenecks. If you look at what's going around, as I understand it, and again, you're going to tell me if you think I'm wrong, or maybe my information's wrong, or maybe I just am out to lunch, but it seems to me when it comes to staffing bottlenecks, licensing agencies sometimes claim to be under-resourced, they don't have enough staff, the people that are engaged in processing the licensing, they're out on maternity leave, or they're out on vacation, or whatever it is, and these staffing shortages make it difficult to, for example, conduct interviews, which arguably are illegal, but set that issue aside, and to otherwise process concealed carry weapons applications. And again, these municipalities allege that they're, they don't have enough personnel, they don't have enough resources to be able to issue these licenses in a prompt and quick and efficient fashion, and that's causing long backloads with applications languishing in many instances months and maybe even years. In fact, I remember being in California in 2024 2024 talking to an Uber driver, and he indicated to me, and this was in the fall of 2024, that his interview to be able to conceal carry was like the following April 2025, and he had to wait like 6 or 7 months to be interviewed, and we were discussing that in an Uber ride, believe it or not. So that's the first thing, staffing bottlenecks that make it hard for them to process applications quickly and efficiently. The second thing is, and this is not a shock, that some of them might be engaging in restricted office hours. If you limit the number of hours in a given week, especially during business hours, as to when you have to show up and do your fingerprinting, your in-person interviews, or whatever it is, or you make it at inconvenient times, that's really super great if you want to deprive people of the right to keep and bear arms. Because if you put all your interview hours in the middle of the work week, in the middle of the work day, or you have some other inconvenient times, then guess what? Everyone that has a job is not going to be able to readily go to the police precinct or the licensing division to go through the process of applying to get a concealed carry permit because they have to actually work. So it seems to be the second bottleneck that may be out there is these restricted office hours to inconvenient times or short number of hours, making it harder for people to actually show up and do what they need to do in the licensing departments or divisions or whoever is responsible for issuing these concealed carry permits in the respective states. The third kind of bottleneck seems to be overcomplicated applications. I've seen some of these applications, and I have to tell you, they're like college applications. They're very detailed, they're labyrinthian, they require excessive information, sometimes redundant information. They're asked to supply references, notarized statements, discussions of past employment history, proof of good moral character, and so on and so on and so on. It's almost like it's a dating website, right? I need to know all this information to date you, but no, this is not about dating. This is about being able to exercise your fundamental right to keep and bear arms, which you should be able to do, frankly, without a license, but that's the subject of a separate video. Again, overcomplicated applications. It's like applying to college or on a dating website where you're getting information that, frankly, you shouldn't have to supply or shouldn't be required to supply to exercise your fundamental right. And that seems to be the third bottleneck that I've been able to kind of flag out there in sort of dialoguing with people. The fourth kind of area here is the burden of supplementary documents. In other words, in addition to just filling out the form, so when you fill out a 4473 NICS background check, you know how it works. You write your name down, your address, you answer a bunch of yes-no questions. Am I a convicted felon? Am I this? Am I that? Yes, no, yes, no, yes, no. And you basically check a couple boxes, you sign your name, you show them your ID, and you're done. They run the NICS check, and that's the end of the story. But here, some of these states are requiring a lot more information. They want, in addition to you filling out the form, they want supplementary material. They want letters from people, references from people. They want character references. They want why you want to carry. They want all this other information in addition to what's on that application. And again, the burden of supplementary documentation seems to be a fourth bottleneck or choke point that the anti-gun jurisdictions in some instances seem to be embracing, and I'm not sure that's appropriate. I would say it isn't, but you'll let me know in the comments below. And the fifth kind of category, as best I can tell, is these sort of unpublished or hidden requirements. There seem to be stories, at least, about secret rules or things that they're looking for that are not obvious on the website. And again, I go back to the metaphor of the NICS check. You know how it works. There's very objective questions. Yes, no kind of questions, name, rank, and serial number, and you're done. And yet there might be secret rules or sort of things that they look for or don't look for as to whether or not they're going to make it harder, have you come back in for multiple interviews, have them go out and interview more people, make phone calls, all sorts of things to delay the process whereby you can actually carry a gun in public for self-defense, consistent with your right to keep and bear arms. And of course, last but not least, we know there's a bunch of excessive fees. We know from the 1960s in the Harper versus Board of Election case, a $1.50 poll tax on your right to vote was deemed unconstitutional by the Supreme Court in the Harper case, of course. And then, of course, we know that a minimal tax on ink was unconstitutional in the Minneapolis Star versus Minnesota case in the 1980s because that violated the First Amendment right to free press for the newspapers in that state, and that was struck down. So, but if you look around the country, it seems to me some of these states, it's hundreds and hundreds of dollars to be able to get your concealed carry permit. It's simply crazy and so unduly unfair, and really it's a regressive tax. So if you're a wealthy guy, it's no big deal to pay a few $100. It doesn't matter to you. But if you're just starting out in your life, your career, you're just starting a family, you're learning how to succeed in business, in your careers, and money is not readily available to you, it's really a regressive tax, and it basically put certain people in a position where they have to choose between spending the money to exercise their right to keep and bear arms, or saving the money for school care or food or shelter or whatever it is. And that is a choice that should not be made based on money when it comes to a fundamental constitutional right. And yet in some of these jurisdictions, that seems to be that kind of fork in the road, that the excessive fees that are being charged to be able to exercise your Second Amendment rights is causing that dilemma, and that is not appropriate. And by the way, I should also note that when it comes to the right to vote, we know that there is nowhere in the United States that you can be charged a right to vote. There is nobody that can charge you a poll tax. That is unconstitutional. Now, by the principles of a fortiori, which means if it's true for the lesser, it'll be true for the greater, here's how I see that. The right to vote is a civic right. It's like the right to serve on a jury, right? The right to vote, the right to serve on a jury, the right to run and be elected to office. These are civic rights, sort of community rights in a sense. Yes, they're your personal right at one level, but really this involves doing services for the community, whether you're engaging in democracy, you're engaging in elected office, you're serving on a jury for the good of the community, whatever it is. This is a different set of rights and a different concept than intrinsic, inherent, fundamental personal rights that are essential to you in and of themselves. And what I mean by this is the right to free speech is part of your basic necessity. It's part of you. It's a personal right. Your right to worship the God of your choice. Same thing. It's a personal right. The right to keep and bear arms is the right to self-defense and to defend your life. It's a personal right. You see what I'm saying? These are personal rights. These are not community rights or civic rights. And the point is that a more fundamental right are those rights that attach to you yourself, and a less fundamental right are those that kind of attach to, in some ways, community duties, community obligations, like the right to serve on a jury, the right to run for office, the right to vote. And I bring this up in the following sense, that if it is unconstitutional and illegal to charge people $1.50 to exercise the community right, the right to vote, which we know is the case from the Harper case in the 1960s in the U.S. Supreme Court, by the principles of a fortiori, it surely is the case that a more fundamental, more important right, the right to keep and bear arms, should be subject to no less protections than the right to vote. And that means we should not have to pay any amount of money to be able to exercise our right to keep and bear arms. That is simply hooey, but the Supreme Court hasn't said that yet, but let's give them some time. So anyway, I just wanted to give you the sort of list of bottlenecks and choke points that it seems to me, from my kind of, review of the literature, from my kind of review of news stories and seeing what's going on X and communications I've had with various friends and other people, that these seem to be specifically where the games are getting played by these anti-gun jurisdictions when they require people to do all this nonsense and jump around all these hurdles and obstacles to exercise their right to bear arms and carry guns in public for self-defense to get that concealed carry permit. So anyway, I'd like to hear back from you in the comments below. Am I on to something here? Am I missing something? Are there other things that are going on, that games are getting played in your community that I'm not aware of? I'd appreciate you sharing it with me and the entire community as to what's really going on here in the real lived experiences of Americans when it comes to this right to carry guns in public for self-defense. So there you have it, folks. Hope you enjoyed today's episode. Make sure you follow me on X at 4boxes. Don't forget to subscribe both to YouTube and to Rumble, and I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.